Humphreys, my lords, my lady. In this matter, I appear on behalf of the appellant, my learned friend Miss Foster, on behalf of the respondent local authority. Well, I'll refer to it as the council after this, if I may. And I appear together with my learned friend, Mr. Humphreys. My lords, my lady, there should be before the court a core bundle, a supplementary bundle, and a bundle of authorities, yes, with the skeleton arguments towards the front of the core bundle. Yes. And I note that there was a request yesterday, I think, from my Lord Justice Lindblom's clerk for a copy of the planning brief and also yes, the absent Secretary of State's skeleton arguments.
That's right, yes, and we received both of those. We've got, I think between us, we've got two colour printed copies of the planning brief, and one of us has only a black and white printed.
No, I've got the colour one.
Oh, you have it? Yeah. So we're all right. We've received those documents. Everything seems to be in good order. We've, of course, read the skeleton arguments and all the, at least, immediate background materials, including, of course, the decision letter, including, of course, the judgment in the court below. You can assume that we are familiar with all of that material.
My lord, this is about as short a point as may find its way before this court, and therefore I won't make a meal of it. My lords, my lady, the other parties to this matter, whilst not in attendance in the court, have nonetheless put in correspondence, and that's the second respondent has put in correspondence at page 29 of the core bundle, yes, and the third respondent at page 31 of the core bundle. And I draw attention particularly to the second respondent because they make observations with regard to what would happen in the event that the appeal was allowed. So yes, I make no submissions about it, I just simply draw attention to that.
Yes, thank you very much for doing so. Is there any need for us to take time over that at this stage?
Not at all.
All right, fine, thank you.
So as the court is aware, this is an appeal against the decision of Mr. Justice Holgate on the 1st of November of last year, which is at tab 7 of the core bundle. Permission to appeal was granted by Lord Justice Levison on the 12th of January of this year, and the conclusion of Mr. Justice Holgate was to quash the decision of Madam Inspector Searson, who issued her decision on the 6th of May of last year after a multi-day inquiry in which myself and my learned friend spent some time up in the northeast, yes, last March.
Yes.
Madam Inspector Searson, as the court is aware, allowed the appeal under Section 78 of the Town and Country Planning Act. That was an appeal in turn against the refusal of planning permission by the respondent local planning authority on the 31st of March of the year before, in relation to an application on the 17th of March the year before that. So March is obviously an important month in the context of this particular case.
Yes, everything has happened, almost everything has happened in the month of March.
Quite so. The court will be aware there was a recommendation following a considerable pre-application process following the existence of the planning brief, which is all set out within the documentation, which I'll turn to in a moment. Right. And the conclusion was that the application will be refused on two grounds, with a third ground relating to unrelated matters about nationally described space standards being added partway through the appeal process.
Yes.
The proposal is for a build-to-rent scheme, in other words, a purpose-built block where the intention would be that each of the apartments will be rented out with amenity space. The application was amended partway through, so it was 289 apartments by the time of the determination and by the time of the appeal, proposed within a single block between 11 and 14 stories high, in a broadly C-shaped configuration. The plot itself, plot 12 of the quayside, as it became referenced, plot 12 is actually a reference to the Terry Farrell master plan, which the court will have picked up from the documentation. Yes. Essentially, this is an area of the northeast which was the subject of extensive regeneration dating back decades. And at a point in time in the early 1990s, the renowned architect Terry Farrell was instructed by the City Council to come up with a master plan for regeneration. A couple of sites remained remain in terms of that regeneration on the north bank of the Tyne, that being a site called Malmo Quay, which is further to the east of this site and needn't trouble the court. Yeah. And in relation to this part of the quayside, the appeal site, plot 12.
Yeah, just pausing for a second. You've mentioned, I think you mentioned the master plan. No doubt you'll mention or may mention the planning brief, which we've seen and looked at. But can I just go back a step? Is there a development plan allocation that is relevant to this proposal or not?
Curiously not, no.
No. So,
And there's
no doubt it was common ground that the site was to be developed, but that is not, as it were, underwritten by any development plan policy or allocation.
My lord, that's right.
Yeah.
There are a number of designations which related to the plan. For example,
Yeah.
it's within an area which is the subject of what's referred to as the Tyne Gorge study, which considered both sides of the River Tyne. It's also, as the court will be aware, within the conservation area, and it's also within the urban area to which there are positive policies in terms of their use and the efficient redevelopment of them in appropriate circumstances, but no specific allocation.
I thought it wasn't in a conservation area. I thought it was.
I'm so sorry.
Two.
Close to a conservation.
Yeah,
Well, it's close on either side.
Sorry to be
There are
pedantic.
two conservation
Yeah,
areas, and
between
it's
them.
betwixt the two, I think. But I just wanted to be clear what the development plan status of the site was. There is no direct policy designation or allocation relating to it.
That's absolutely right, my lord.
Fine, right.
So it's probably most convenient to turn to the development brief in terms of identifying the nature of the site itself.
Yes.
Appreciating that the court will be aware of this already.
Yeah.
But if one turns to page 5 of the development brief,
Yeah.
which happily the court has in coloured, so I can explain the different colours in relation to matters as well as the configuration.
Yes.
So on the south, it's configured north-south in terms of this plan. On the south side is the River Tyne. On the north side of the blue outlined area is City Road.
Yeah.
Immediately to the north is a budget hotel, and then to the northeast on the other side of City Road is St Anne's Church, which obviously has prominence in the context of this case.
Yes.
The differential between the blue and the red on this plan simply shows the land ownership of Homes England, who are the successor body to the regeneration company that had originally had the land vested in them in this matter.
Yeah.
And the red edge is the anticipated area of the planning application that the planning brief was seeking to bring forward.
Yes.
There is, as one would expect, moving away from a river and in a location where there is a study called the Tyne Gorge study, a differential in height between the south and the north. One sees that a little further into the documentation.
Yes.
You can take the court to, for example, page 20. Sorry, my notes are going right. Page 24.
Yes. Yes.
Where one can see on a cross section the River Tyne in blue to the left hand side of the page, the spire of St Anne's Church there, and the appeal site with the potential blocks for redevelopment shown on it in pink. But one sees in cross section the differential in height, and that explains why on one side one has 11 stories, on the other side one has 14 stories.
Yes.
If one looks at page 9, which is also on the front page of the document,
Yes.
there's a useful aerial photograph which perhaps explains some of the discussion in the document,
Yes.
which shows, now that one's aware of the cross section, the sloped nature of the site within which there is a large retaining wall. One can see St Anne's Church and one can see the development either side.
Yeah.
My learned friend Mr Hardy, who appeared in the court below and also appeared at the local inquiry, described the site as being a gap in the teeth, which is not a bad description of it, frankly. But one can see how it is an obvious gap in terms of the development area, and one will see in due course that it was identified as being essentially an accidental remnant of the regeneration process, when I'll take the court to the Historic England letter in a few moments, if I may.
Yes, fine.
So in terms of the background to the matter, My clients came to the site, the appellants came to the site following the planning brief having been produced. The planning brief has no formal policy status. It's a document that was produced by consultants commissioned by Homes England. And one sees from page 4 of the planning brief itself that it was a document produced by consultants commissioned by Homes England, but in collaboration with Newcastle City Council, Respondent Council, and hopefully together with the planning brief the court received Appendix A of the planning brief, which is a letter from Newcastle City Council, which I don't read but invite the court to have sight of, because it essentially identifies support and confirms the collaboration. My Lords, aware that the court has read the judgment of Mr Justice Holgate, can I commend to the court, but without reading it, paragraphs 10 through to 17, which sets out the history of the matter up to the point of the planning brief. And that's a history that goes all the way back from the 1960s through the involvement of the Tyne and Weir Development Corporation and what they approach matters.
Yes.
And I particularly draw attention to paragraph 15 of that section of the judgment, which identifies that it's a site where there's been a number of attempts to bring forward redevelopment, and it's referred to as a notable gap site by Madam Inspector Searson, which I'll come to in a few moments. So, difficult site to bring forward, topographical issues, sensitivities, and heritage implications. My Lords, my Lady, if I can turn to the decision letter. Yes. Which is tab 7, starting at page 101 of the bundle. Draw attention to the main issues of paragraph 7 of the decision. So we have effect on the character and appearance of the area, effect on designated heritage assets, effect on internal living conditions of future occupants, it's described as. That relates obviously to the development itself, but also effect on the living conditions and outlook of those residents of St Anne's Quay, represented by the Rule 6 party at the inquiry. When one looks at the decision itself, it's fair to say it's a tour de force. So we've got a 23-page decision, 154 paragraphs of Madam Inspector Searson's decision, covering a wider range of issues. So by way of example, in relation to character and appearance, almost everything was at issue: footprint, scale, quality of architectural development, mass, height, sunlight and ingress, daylight ingress, the extent of space standards within the built form itself. So we had building line, lots and lots of different things in relation to the issue of character and appearance. This was a decision which covered a very wide range of issues, even within the main issues themselves. And I make that point for the obvious point, which will be obvious to this court, that one is told to read decisions as a whole, read them fairly, read them benevolently, not read them as if one was in a university seminar. That in those circumstances, one has to read them with a benevolent eye. Reading it as a whole, I say we are focused in this appeal on a very, very, very small part of of one of the main issues, but one has to read it within the context of the decision, which is ranging far and wide, and that Madam Inspector Searson, whatever she was doing, was not writing for the level of scrutiny that a university seminar or an examination paper would be scrutinised. And it's in that context that the criticisms which led to Mr Justice Holgate's conclusions in relation to that part of the decision related to St Anne's Church should be viewed, in my respectful submission.
I imagine that's all common ground. That the question of approach, ultimately the question may be, what do the words mean?
Absolutely. And that's where, drilling down, we then have to drill down to essentially 2 pages with a couple of forays into other parts of the decision. But it's essentially pages 110 and 111 that we need to focus in on. Before I do, can I just focus in upon where all of this takes us? So if one turns to page 119,
Yes.
which is the planning and heritage balance, I was long ago taught that one should be reading decision letters from the back to the front for a whole series of reasons. That's probably the fault of the late Miss Justice Gilbert. But there we are.
I dare say that most parties go straight to the end to find out what happened.
Well, you say that,
or
my
even
lord,
the
but
beginning, because I think now the modern format of a decision is to tell everyone what the outcome is.
It is, but in the first paragraph now in a planning inspector's decision. So it's true for judgments, one always turns to the end to look at the last sentence, but for a planning appeal, it's always the first sentence these days.
Yes. Well, some judgments, of course, these days do not go in for suspense.
Yes, I think the planning
Even
inspector...
the false notion of suspense that assumes that the parties will not go straight to the end. But you've gone straight to the end.
I have, my lord. But really to corroborate what Madam Inspector Searson concludes at paragraph 1. I do invite that the court, when looking at the 2 pages upon which we're going to focus in just a moment, to read them in the context of where all of this takes us and whereabouts it slots into the overall decision.
Yes.
So we've got overview of findings at 130, where we've got a reference to the harm to St Anne's Church that I'm going to turn to.
Yeah.
She finds some limited policy conflict in relation to character and appearance. That's the quality of the architecture that she turns to, which I won't take the court to. And she's also found harm to the setting of St Anne's Church, qualified as being towards the lower end of less than substantial harm.
Yes.
It's the point that the parties no doubt have both underlined in red. I have, however, found no harm to other heritage assets. Just noting in passing, there were a range of heritage assets which were at issue as between the City Council and the appellants at the appeal, and also the appellants and the third parties.
Yes.
Over the page at 120, she considers the benefits of the scheme. Again, I don't read those out, but just draw attention to those. Save to say that she gives, at the end of 137, substantial weight to the benefits, and then she dips into the planning balance at 138. And I draw particular attention to 139 and 140, where she highlights that it's clear to her that plot 12 is an exceptionally difficult site to develop with many competing elements. And in this regard, it's a finely balanced decision with clear policy conflict, but with important and weighty material considerations in play. And then talks about the credibility of the witnesses, which was regrettably an issue in this case, certainly so far as the Rule 6 party was concerned. And then says, beginning with heritage, any harm to heritage assets should be given considerable importance and weight. Nevertheless, greater weight can be afforded to the public benefits. The benefits outlined above would comprise public benefits for the purpose of this balancing exercise. Taken together, the improvements to the churchyard, the repairs to St Anne's Stairs, plus the more general economic, social and environmental benefits are more than sufficient to outweigh the lower level of less than substantial harm to the significance of St Anne's Church. I am thus satisfied that there is a clear and convincing justification for that harm in accordance with paragraph 202 of the framework.
Yes.
That's relevant, as the court may be aware. Certainly I can take the court to the bundle if necessary. Paragraph 202 of the framework, MPPF, requires an internal heritage balance.
Yeah.
In other words, whether harm to designated heritage assets is outweighed by public benefits. That's a requirement as part of the overall planning balance. And that's something that Madam Inspector slots into her consideration and concludes that there is a clear and convincing justification for the harm in accordance with that paragraph. That's not an answer to the criticisms raised by the City Council, but it puts in context whereabouts those criticisms lie.
Yeah. Just a small point, while it's in my mind to mention. I know we're going to be looking at this in some depth, no doubt. If you come back to page 111, paragraph 71 of the decision letter, there's a footnote 7, which refers to paragraph 199 of the NPPF, I think. Should that be 195, or is it correct, actually, is it 199? It is correct.
I'm pretty sure it is correct, Mark.
I only asked because the focus seems to have fallen rather more on paragraph 195 in the arguments below and here. But that's a correct reference, is it?
That's my understanding, my lord.
I have to say I didn't do the work for myself and go and check, but it does seem slightly odd that she footnotes paragraph 199 when actually we're really looking at 195 and 202. Anyway, it's not a criticism, it's simply a query. Don't worry about it now.
My lord, I think it is right, because that's dealing with the issue in terms of weight. And that's why she's footnoting it in relation to that sentence.
Simply that, yeah.
Because what happened following the Barnwell Manor case was that the NPPF was tightened up in terms of ensuring that great weight, considerable weight is given to any impact upon heritage assets. In fact, following my Lord's decision in the Forgefield case as well.
Yes, that's right.
So I think that the reason why that's footnoted there relates to the issue of weighting rather than paragraph 195.
So I took a false point. That's fine. Thank you. You've cleared it up. Yes, so we were looking at 139 and 140. You've mentioned paragraph 202 of the NPPF.
My lord, yes, I'd finished on 140, essentially to draw attention to where all this leads to.
Yeah.
And it leads to two places. It leads to the internal heritage balance at 202. But obviously one doesn't just weigh the heritage harms into the internal balance, one weighs them into the overall planning balance as well. And there's no criticism that Madam Inspector Searson has done that in terms of what she's set out to do.
No. But this is where it culminates.
Quite so.
Right.
And the court's already seen from paragraph 130 that whilst there are a variety of different assets that were live in terms of impacts between the parties, it was only in respect of St Anne's Church that she concluded that there would be harm. Hence the focus in 130 upon St Anne's Church.
We're also taken, I think, by Ms Foster to, just as it were, en passant to paragraph 76 and 77. Though this is not, as she makes clear in her skeleton argument, the subject of any direct attack. But she does compare the language in 76 and 77 relating to Sailor's Battle with that in the paragraphs that we're most concerned with.
Yes, my lord, and I think in fairness my learned friend is responding to an argument that we put lightly in the skeleton in relation to the approach to Sailor's Bethel. It's not a direct legal challenge in relation to matters, and to be blunt, it's probably a bit of a sterile argument because either the points are right in respect of St Anne's Church or they're not right in relation to St Anne's Church, and whether she may or may not have fallen into a similar error or not fallen into a similar error elsewhere probably doesn't help either of the parties in relation to that point.
Its potential relevance might be, however, that the style, if you like, or the language adopted in that part of the analysis may or may not replicate the language of 70 and 71. That may be, as it were, a tangential relevance to it, but otherwise we are really, as you've said, concentrating on 63 to 71.
My lord, yes. My lord, before turning back to the relevant part of the decision, can I just draw attention to two other points of context, if I may? Firstly, in the supplementary bundle, and to the Historic England correspondence which the court has.
Oh, yes.
There are two letters at tab 1.3 and 1.4, just to explain why there's two letters. Between May of 2020 and November of 2020, there was a reduction in terms of a lower storey extension of the proposed building to the east within what I'll show the court in a moment is the view corridor on the planning brief for St Anne's Church. That was removed between May of 2020 and November of 2020, and that's referenced on page 56 of the supplementary bundle, where one sees essentially Historic England standing by their previous advice, but under the advice it says the amendments present a reduction in the eastern width of the proposed apartments. This gives a slightly wider viewing corridor between the River Tyne and the Grade 1 listed St Anne's Church, but then talks about the increased space is noticeable, the church more prominent. However, this is a relatively narrow field of view, and the blocking impact of the proposal remains a concern that causes a moderate degree of harm.
Yeah.
So that's why there's two letters. The first letter is where one has the analysis, and that reference to moderate degree of harm one sees on page 53 on the penultimate paragraph of the section which deals with the advice of Historic England. So the paragraph that starts to conclude the setting of St Anne's Church, as expressed by its relationship with the river, makes a strong contribution to its significance as a Grade 1 listed building, and the curtailing of that relationship will be harmful to its significance to a moderate degree. Yeah. Mitigation reduces harm but doesn't remove it.
The recommendation which follows is in possibly characteristic style for such a letter. Historic England has concerns regarding the application on heritage grounds. We consider, it says, that the issues and safeguards outlined in our advice of the 15th of May 2020 need to be addressed, it says,
yes,
in order for the application to meet the requirements of paragraphs 194 and 196 of the NPPF. Need to be addressed is the phrase. Does that mean considered by the decision maker, or does it mean tackled by way of substantive change to the design?
I think the latter, my lord, because the paragraph which starts, paragraph 194, 196 on page 53, then goes on to say that there is a requirement for the clear and convincing justification. That's a reference to the earlier version of NPPF in terms of the paragraph numbers, lest there be confusion. It says there has to be a clear and convincing justification once the contribution of mitigation has been factored in. ... Harm significance is considered against the public benefit of the proposal. We consider this balancing exercise is required in this instance, but note that the LPA is best informed to make the decision. So it's deferring the overall balance and whether there is a clear and convincing justification to my learned friend's client.
Yeah. Yes, we need to be careful with versions of the NPPF then, do we?
We do. This was an earlier version of the NPPF.
Yeah, so we just need to note, refers to earlier version of NPPF. Do we have that earlier version?
No, my lord, but we can certainly get copies of those paragraphs.
I actually think it would be helpful just to have them, lest we fall into error in referring to the wrong paragraphs. And the paragraph numbering is very similar, of course, to the revised version.
It is. NPPF went through very few changes until this decade started, and then it's been through a flurry of additions from government.
Yeah. The inspector, when she made her decision in March 2022, was referring to the then current version of the NPPF, which remains current.
That's her paragraph numbering are the same as the current NPPF model,
yeah.
which is the one in the bundle.
Yeah, fine, that helps. All right, we've got that.
So my lord, they are essentially drawing attention to the same balance that Madam Inspector Searson draws, albeit under paragraph 202. If one turns to the preceding page,
yes,
that there are words that the court will find perhaps resonates with some of the observations of Madam Inspector Searson. So under the advice, one has the focus is upon the impact of St Anne's Church.
You're looking at page...
Page 52, my lord.
52, right.
So the preceding page. I'm so sorry.
Yeah, okay.
So the first paragraph tells one that focuses upon St Anne's Church as a Grade 1 listed building. Then talks about the changes to the surrounds of the church over time.
Yeah.
Then one has the visual connection with the river is greatly helped by the openness of plot 12. This is accidental rather than long-standing or intentional, and it is acknowledged that the redevelopment of the plot is in line with its past history and current land use in the area.
Yeah.
The issue is how continuing the established height of development along the City Road curtails the last large open vista between the church and the river.
Yeah.
And then one has discussions about the nature of the curtailment on the next page. The reason I draw attention to that, and I'm going to take the court to the brief in just a moment, which makes a very similar point, is this. It is an important feature of this case that there is a particular context. And the context is that the baseline against which harm is judged to the church is self-evidently as the site is now, but knowledge of that context is viewed as being important by historic England. In other words, the gap is an accidental gap, and concerns about the fact that filling that gap to an extent would have an impact potentially on St Anne's Church. So historic England draw attention to that particular point.
Yeah, I mean, the point is that there would have been quayside buildings on plot 12 when this was an industrial area of Newcastle.
Exactly, and the reason... I'm so sorry.
No, that's all.
Indeed, one can see those, my lord, within... if one turns to the end of the supplementary bundle,
Yeah.
one has the heritage witnesses evidence
Yes.
from my learned friend's heritage witness.
Yeah.
If one starts at page 74 of the supplementary bundle,
That's right. Well, we've got the maps.
one has the maps, and one can see how the area of the quayside on page 74 formerly had built forms upon it, and then one also then has moving across on page 77,
Yeah.
somewhat charmless nature of the site as it was in the 1960s.
Yes. City Road. There was once a street named Horatio Street.
Yes, and there still is such a street.
Yeah.
That's to the east of the
East,
plot
yes.
12,
That's to the east of plot 12.
where
Yes, I
there's
see,
now
yes.
three-storey development.
I see.
It appears to be where the Sailor's Bethel is located.
Quite so.
Basically.
It runs up the hill to a monument.
Yeah. But anyway, we can see even if we look at even the 1942 map, figure 5, it's tantalisingly truncated, isn't it? But it's there's clearly a development to the east of the site. Is that right?
Yes, there's development to the east of the site and along the City Road frontage.
Yeah.
And one also sees that from the first edition map from the late 19th century.
Yeah.
Just to orientate oneself on page 74, the church is directly under the S&T of east. So one needs to go southwest from that to see the appeal site, and one sees the building.
What I can't tell from that is how high the buildings are, though, in the first two rows.
No, my lord.
If they're one story, it's not a problem. The church is up above.
My lord, it depends on where one's standing, to be blunt.
I suppose, yes.
All right. What is it? That's very clear. Thank you. Yes.
And my lord, to my Lord Justice Lewis's point on page 76 and also page 78, one sees the view down Horatio Street.
That's down to Horatio Street.
Yeah, with the Sailor's Bethel on the right-hand side. and on the same page 78, one sees the nature of the quayside as it was in the 1980s. If my lord has a recollection of the time, one sees Baltic Mill on the south side of the River Tyne, perhaps helps to orientate the viewer.
Yeah.
And whilst I'm here, it may be useful to just turn to page 83.
Yes.
Page 83, which is broadly from the other side of the river to the south. So
Yeah.
one sees the notation is directly above. So photo viewpoint 6, which is the middle of the photo viewpoints, one sees the site as it is at the moment, with its slope covering over the retaining wall. The proposed development at the bottom, page 83, and one can see St Anne's Church there. What one also sees on page 83, sorry, I do apologise, on page 84, it's probably better, is to the right of the site is a series of steps that go up, which are referred to as St Anne's Steps.
Yeah.
And that's relevant. So I'll take the court to the brief in just a moment, because the intention of the brief was to retain a view corridor, essentially up the steps towards the church, that one could see from a hotel on the south side of the Tyne roundabout, where a hotel called the Jury Hotel, not that it matters, where that view corridor would be evident.
Yeah. Right.
So
Yeah. Understood.
So, my lords, my lady, if I can then take the court to a similar reference in relation to the accidental nature of the gap sites, as it were, within the brief, page 10 of the brief.
I mean, does that matter that it's accidental? When you're assessing harm, it's there now and has been for about 30 years. Did you say, well, it's terrible harm, but it's only accidental, that it looks so lovely now? Is it relevant?
It is.
Oh, right.
This is why it's relevant.
Oh.
My lord, I don't say that it tempers harm. I say it's relevant when considering weight.
Oh.
Because a distinction can be drawn between a site where the effect of a site is that one has an open vista because something's been knocked down, with the anticipation that it was always going to be regenerated. So on the one hand, and a situation where it's always been open and you're putting somebody there, something there in the first place. My point is a simple one, that everyone that's come to this site, one has the brief, one has Historic England, one has Madam Inspector Searson, other documentation that, if necessary, I can reference in the closing submissions, have pointed out that this is a site which is open because of its accidental nature arising from its regeneration. There was an expectation that there would always be something here.
So in terms of weight, it's a temporary benefit, really, so you've got to take that into account.
Absolutely.
Yeah, okay.
And therefore that's relevant for weighting, because the sentence that we're going to focus upon ends with what weights to be given to the matter.
Yeah.
I mean, there is the concept of the historic setting of a listed building.
There is, my lord.
Some listed buildings will have their setting largely intact. Others, where there has been change in economic circumstances, such as here, the setting will have changed considerably over time. And the accidental gap is a product of that changing history, or the fluctuations in that history, if you like, between prosperity and the absence of it.
My lord, yes, and between different natures of the structure of the local economy.
Of course.
This was a location to which there were railway yards, to which
this was a working quay.
Absolutely. This was full of stevedores and noise and activity at the time of the church in its heyday in the 19th century. When it was originally built, it was in a field divorced from almost anything, as is pointing out in the documentation. Yes. It was isolated. Over time, this is a church that's changed.
Yes. That's all understood.
So the reference I was going to take the court to is on page 10 of the brief.
Yeah.
Where one has, under historic context, again thought to be relevant by Homes England in collaboration with the City Council, the end of the second paragraph, which starts off talking about the hive of industrial activity. The site was cleared as part of the redevelopment of the quayside in the late 20th century and has stood empty for a number of years. Exactly the point that was being discussed. Historic environment. The site contributes to the setting of St Anne's Church, which is identified as a Grade 1 listed building. It is acknowledged that any proposals for development on the site would result in a level of harm to the setting of St Anne's Church. Any proposal for development of the site should look to ensure that the level of harm is considered as less than substantial as identified within paragraph 134 of MPPF.
That's a previous version again, I think.
It is.
Yeah.
But the point is that this is another public body coming to this site, drawing attention to the expectation of redevelopment on this site and the expectation that redevelopment would impinge upon the harm to the listed building.
Over the page on page 11, you have a heading, historical analysis and constraints.
My lord, yes.
And the word constraints appears several times in the document. Do you wish to say anything about that?
Well, my lord, one point is the point I was going to draw attention to, is the second paragraph under historical analysis and constraints.
Yeah.
Because it's a point that is made elsewhere in the document, but made here perhaps the best. Talks about views to and from St Anne's Church evolving over time, having a strong connection with the river. ... Then halfway down the paragraph, currently the vacant and neglected East Quay development site, the appeal site, detracts from the experience of the surrounding heritage assets. The setting of St Anne's Church and other identified assets, heritage assets, must be taken into account in any proposals coming forward. So the authors of this document, certainly at that time, thought there was an issue in terms of it appearing in its, if I may put it this way, raw form following the regeneration.
Yeah.
Context being of relevance when discussing the effect on heritage.
Yes.
If I can then take the court to page 22.
Yeah.
This is in a section which discusses what could come forward on the site. And I draw attention to the shading area on the right-hand side of the plan.
Yes.
So that, on the shading area, one can see the notation at the top that says 7 view corridor. I'm going to turn to what's said in the document about that in a moment. But one also sees the... I'm trying to avoid in an august court of this nature the avoidance of the term wiggly line, but I can't think of anything else off the top of my head which is better.
But that's what it is.
My lord, one sees the wiggly line in the view corridor, which comprises St Anne's Stairs.
Thank you. Yeah.
If only Mr Humphreys was doing the advocacy, he'd have a far better word than I. But my lord, the view corridor encompasses St Anne's Stairs, and if the plan were to be extended to the north, that's a view towards the church itself.
Yeah.
So essentially creating a narrow corridor of vision, so there would be a viewpoint of the church down that corridor, and one sees that on the next page. Item number 7, page 23, a perpendicular visual connection between the church of St Anne and the River Tyne. Just noting, my lord, I think we agreed at the inquiry that it was Anne without an E. It appears in different forms throughout the documentation. But on the interpretation board outside the church, it's Anne without an E.
Yeah.
So a perpendicular visual connection between the Church of St Anne and the River Tyne is recognised as important within the heritage analysis and referenced in the listing. Within this view corridor, an opportunity for forming a viewing resting platform at the head of the existing stairs to the east of the site is recognised as a community benefit.
Yeah.
And one sees above that...
So does that mean they'll stop their kinetic movement and sit down and look at it?
Well, they'll be shattered by that stage, my lord.
That's what they mean, they're going to put it somewhere where you can rest and look at it.
That's I think, what's intended. There at the moment a series of stairs which are wooden and in need of
They're
work.
going to be repaired, that's one of the benefits.
Correct. But yes, the intention is somewhere where one can stop and look at the church. But equally, if one imagines that one's looking, appreciate this is orthogonal projection, that from the south side of the Tyne, that's the view that one would get of the church, and indeed standing on the quayside itself.
Are there any montages that show that glimpsed view or vista or whatever it is? The corridor.
There were, but I don't think they're in the bundle.
It doesn't matter. I think we can visualise it. The
They're
point
anywhere
being
in-
that if you're on the other side of the Tyne and you're walking along, there will be a longer period if you're walking along when you can't see the church than there is now, but then you come to a point at which you look through and you can see the church for a number of steps as you go.
Yes.
Or you can stop and see it through that viewing corridor, and then you move on and it's gone again. Yeah.
I think with the sort of flourish that one can hopefully forgive an advocate, I compared it within the closing submission, which is in the documentation, to the sort of framing that one has by the Millennium Bridge of St Paul's Cathedral. It's that sort of framing of the church between built form and then one moves on. There is a walkway on the south side of the River Tyne, albeit it comes to a stop just after the Jury's Hotel, where that view would have been available, there being a further redevelopment that's coming forward in that location.
Yeah. All right. That's fine. Thank you.
So that's context.
So we're going to come to the real business here, which is these paragraphs 63 to 71.
My lord, yes, and it's tempting to just invite the court to do that and sit down, frankly. But my
Well, I mean, can I just, as it were, frame the discussion? I hope not to constrain it, but frame it. It's as we understand it, I think it seems to be common ground, and always was, that there would be some. Well, this changed a little, I think, at the inquiry, but there was pre-inquiry a consensus that there would be some harm to the setting of the Grade 1 listed building.
yes,
I think the developer's witness at the inquiry, as it were, resiled from that position and said no harm.
that's right, my lord.
That was an evidential moment, as it were, which is recorded, I think, in the inspector's
Paragraph 67, my lord.
paragraph 67. Where the consensus came to rest, apart from that diversion, was that the harm would be less than substantial harm.
Yes,
And the inspector agreed it would be less than substantial harm. But she placed the harm at the lower end of that category or classification, as she called it.
yes,
So far, so good. And I think all of that is really a matter of record.
my lord, yes.
Then there is this question, which again may be common ground too, which is the question of what this means. If there is harm, be it less than substantial harm or any kind of classification or category of harm, that exists as what I'll call, may not be the right words, but I'll call it as an absolute concept. It is what it is. And it doesn't get greater or less according to the possibility of some alternative design. It is what it is.
Yes,
That doesn't make an alternative design irrelevant. Indeed, it's mandatorily relevant through the policy in the NPPF.
yes.
But is it common ground, as you see it, Mr. Tucker, that, and this is entirely leaving aside what the inspector meant in paragraph 71 for the moment, that as a basic logical proposition, harm is what it is, and it doesn't improve or lessen with the possibility or absence of an alternative design. That's a logical proposition, which I think is common ground between both sides.
My lord, it certainly is from our perspective, and it's inevitable, I think, from my
Ms.
lord
Foster has indicated that is right. So far, so good. So then, that is it, if you like, the frame for looking, obviously in context, at paragraphs 70 and 71. I don't in any way want to steal thunder where I shouldn't, but what we have in the build-up under the heading St Anne's Church on page 110 is a series of paragraphs 63 to 69 in which the inspector considers a series of considerations to do with physical and visual circumstances and change that would take place, and to some degree an evaluation or assessment of that change.
Yes.
Then we come to 70. In 70, she is clearly concerned with what might be described as a comparative consideration in the notional world of some alternative scheme, or the absence of it. Alternative design, actually, to be more precise. And she reaches the conclusion that she does in 70. No criticism, I think, is made of paragraph 70. And then in the culminating paragraph of this part of the, or section of the, or subsection of the decision letter, which begins with the word overall, there is the clear assertion or contention or conclusion the level of harm to St Anne's Church is less than substantial.
Yes.
She then acknowledges that it still amounts to a significant objection. And she reminds herself and the reader, lest there be doubt, that the more important the asset, the greater the weight should be, and she gives the cross-reference for good measure to the NPPF.
Yes.
And then we have really what is the focus of this appeal, which is the sentence. However, then this parenthesis, given the key constraints of the plot and the nature of the harm identified, end of parenthesis. This is towards the lower end of any such scale within that classification. Leaving aside the parenthesis entirely for the moment, the last part of that sentence, the last clause of the sentence, is clearly a reference back, isn't it, to the first part of the paragraph, less than substantial.
Absolutely, my lord.
She is qualifying that initial conclusion.
Agreed.
Beginning of 71. So then we bring our minds back onto the parenthesis, which is really the substance of this appeal.
Yes.
What does she mean, is the question. What does she mean when she says, given the key constraints of the plot and the nature of the harm identified? And does it really resolve to this? Does she mean, when she says, given the key constraints of the plot, the things that I've been considering, especially, I do stress especially, in paragraphs 63 to 69. I say especially because there's 62 paragraphs before 63 to 69.
Yes, yes. That's understood.
Does she mean, when referring to the key constraints of the plot, to be referring to those considerations, and especially her consideration in 63 to 69? In other words, she's reaching back over paragraph 70. Or is she actually, as the judge held, we think, embracing paragraph 70, and in particular paragraph 70, because it immediately precedes paragraph 71, and actually bringing on board what it seems is not logically correctly placed there. That's to say, a comparative assessment rather than the absolute one, which is contained in 63 to 69 and the first sentence of 71. And is it a simplistic version of this case, or this appeal, to say that that really is the question? What does that part of the parenthesis mean? Is it the first of those alternatives or the second?
My lord, I would add, when reading a decision benevolently, as we are told that we should, is one assuming that the inspector is reading it in the, if I may, legalistic way that I would contend for, of saying that only references back to the preceding paragraph, or reading it benevolently, is she reading it in the way that my lord posits as the alternative?
Yes. I mean, the judge was very clear on this and very definite. The judge used language such as, this is the only way you can read it,
yes.
no other way one sensibly could, or whatever he actually said. pay attention to what he actually said. The argument against you relies to some degree, as we'll hear no doubt in due course, on the conjunctive and the nature of the harm identified, which is said to be a separating conjunction. That's to say, it emphasises the nature of the harm identified as an additional and different factor from the key constraints of the plot. And the key constraints of the plot is principally, says Ms. Foster, the comparative analysis undertaken in paragraph 70, which is logically irrelevant to the absolute assessment of harm. It has a place clearly later on, or elsewhere, but not here, says Ms. Foster. And that's the error. And the judge was very definite in the conclusions he reached to that effect.
Indeed, he says no doubt that was his interpretation.
So I'm sorry about the lengthy framing, but that's all in an effort really to see that we've understood the issue that lies between you.
My Lord, it seems to me that my Lord has encapsulated the issue between the parties absolutely. If I may just take a step back a little to look at a couple of points. One point two points I would stress about paragraph 71.
Yeah.
And whilst criticising others for being legalistic, I'm going to be a grammarian for a moment. The paragraph starts with the term overall.
Yeah.
So that's telling the reader that this is doing something, taking what has gone before altogether. If one wants the hook that one is hanging this paragraph on, it's not the preceding paragraph, it's overall. I'm bringing everything together.
Well,
that's...
Yeah.
Sorry,
but
Mark.
overall must include the previous paragraph
Of course.
as well.
Yeah,
And
self-evident.
even if it's a little bit pregnant, it's still a baby.
Yeah,
Sorry, you know what I mean? Yes, you're the housewife. I haven't put that clearly, but you know what I mean.
my Lord, I know exactly what my Lord...
Very clear.
Yes. The binary nature of pregnancy, yes. There's a certain irony because when this matter was argued before the High Court, my learned friend was indeed pregnant.
Congratulations, sorry, I didn't know.
In fact, the timing of matters means that my learned friend went through the entirety of the process from start to finish through this
But
case.
you can see what I mean. If it is overall, it's got to be 60 to 69 and 70.
Of course, my Lord, and that's my point. So if we want to take a step back from this and structure this and say, what is Madam Inspector Searson doing in these paragraphs? If we want to start to put subheadings in relation to these paragraphs, there's some fair clarity as to what she's doing. But the subheading that you would put on the paragraph of 71 would be something along the lines of bringing everything together.
Or conclusion.
Yeah.
Concluding, as indeed she uses elsewhere. If she decided yet another subparagraph within all of the subparagraphs, overall is telling you, I'm referencing everything that I've said before, not just paragraph 70. Now that becomes important when we look at paragraph 71, perhaps a little more detail. The second grammarian point that it goes against my nature to make, but I make it anyway, is that the last sentence has a subjunctive clause within it. So the subjunctive clause is bounded by the two commas, and one can read a sentence by taking the subjunctive clause out. However, this is towards the lower end of any such scale within that classification.
Yeah. But it must be because of what's in it's the given that the reasons why she's put it at the lower end is those two things.
My Lord, yes, and that's the point I have to grapple with to convince this court that that's right. And I start off by saying, as indeed I think that I say or we say in the skeleton argument, that she would be marked down if one was marking this as an essay. But
well, would she? Would she? That depends on what she means.
Yeah.
And it does come back to what she means when she says, given the key constraints of the plot. Because
Sorry. You said something about a subjunctive clause. Where's the subjunctive?
Well,
do you mean subordinate?
Subordinates, I'm so sorry.
Oh, right.
That's
You're
why it
doing
goes
grammar,
against my
Mr.
nature, my lady.
Thacker.
I was
Well,
badly
that's
taught,
fine.
my
As
lady.
long
Sorry,
as I understand.
if we could just come back to the question I was raising. The words are there. They're not to be taken out.
No.
They do mean something. The question is what they mean. And I just wonder whether I can move us a step or half step forward by focusing on a particular word, of course reminding myself that when one approaches this in the benevolent style that you've indicated, there's ample authority for that. So I remind myself of that. But I look at the word constraints.
Yes.
And I ask myself what a planner normally understands by that word. And what a planning audience normally understands by that word. Does planner and a planning audience normally understand by that word the kind of considerations at which we were looking just now in the planning brief? And indeed, though she doesn't, I think, previously use the word constraints in the decision letter up to that point, I may be wrong, but I think I'm right in saying that.
I think my lord's right, actually, having done a word search.
But she's looking, as a planner does, at the physical, topographical limitations, obstacles, parameters, what have you, that in 3 dimensions constrain the opportunity that exists to put a development on this site where it hasn't been for a very long time. There may be other constraints, such as policy constraints, which are, if you like, the content of the master plan documents and the planning brief. We've looked at the planning brief, which themselves operate as factors for the decision maker to pay attention to, and which, to a degree, constrain the decision maker's decision. So when a planner finds the word constraints, does the planner understand it in that sort of way? And how does that help us to understand what this planner, the inspector, meant when she said, given the key constraints of the plot, is the question.
And my lord, to help in terms of the answers to that question, if I may, if I can take the court to page 12 of the brief.
Yeah.
Because the object of that first part of the conjunctive element of the subordinate clause, which I will never forget again. But the first part of it talks about the constraints of the site. What is the site?
Well, that's another thing. In your scouting argument, you incorrectly reproduce 71. You say the key constraints of the site, and it's not the key constraints of the plot. And I had thought, when I read it first of all, if it was the site, it could refer back to 64. Not the application site, but the broad area. And then I thought, no, it's not that, because the plot is plot 12. And I thought, no, when she talks about plot 12, she's got it in capitals at 12. So then I wondered, why do you change from plot to site? Ms. Foster does the same. And then, what's the relevance of plot? There's key constraints, and key constraints of what? So what does the plot mean there? Why did you change it to site?
Well, that's almost certainly a gross error, my lord, and my work needs marking
lack
once
of
again.
education. Yeah.
Lack of education again. But my lord, that's something to take up in a different place. But in terms of plot, it's not talking about the development.
It's not, is it?
It's talking about
plot 12.
Well, my
If
lord,
it's plot 12, the only time you get plot 12 is in paragraph 70, so you need to help the other side. But if it's not plot 12, then it's easier for you.
well, my lord, the only thing I can say is it is that which is undeveloped.
Which is undeveloped.
And my lord, I have to accept that it's not precise as to what she means by plot. And my lord is absolutely right that she doesn't use the capital and she doesn't say plot 12 there. But that might just be infelicity, who knows? But my lord, in terms of the site, if I'm right that it's synonymous with site, which until 2 moments ago, my lord, that would be my submission.
Yeah.
If one turns to page 12 of the brief, what are the key constraints of the site? Well, there's pretty significant topographical constraints that one sees on page 12 of the brief. There's also the fact that the site is a double-fronted site. And more importantly, the key constraint is it interposes between St Anne's Church, the churchyard, and the river. And that relationship is important. The biggest constraint of the site or the plot is where it is and what it is.
So, paragraph 71, colloquially is, however, given what's there, and given the harm that's going to be done by it, it's the lower end. That's what it means. It's
That's
given
exactly
what's there.
Yes. Prefixed by the point that she's drawing in everything that goes before to reach her summary conclusion. And just to pick on a point that my Lord Justice Limbaugh made a moment to me ago. Is there something wrong with that subordinate clause? Yes, there is, because it's not entirely clear what she's referencing, unless one reads it with a benevolent eye.
Well, you say everything that's gone before. Well, everything that's gone before includes paragraph 70.
Yes.
I wonder whether you really mean everything that's gone before, or that which is clearly related to the assessment of harm, because that is the point that she introduces at the beginning of 71 by way of...
My Lord is absolutely right. My Lord is right. That is a distinction that I make, which I do make in the...
Yeah, but you've got to be careful with this, because paragraphs 70 and 71 are in the order that they are. We might not be here if they'd been the other way round.
Well, self-evidently we wouldn't, my Lord, yes.
If you'd simply flipped 71 and 70, we might not be here. But we can't do that, because the inspector wrote it the way she did. And the question, therefore, is, I would suggest, perhaps, not actually whether it's everything that's gone before, or what she must have been referring to in 71, which is the constituents of harm.
My Lord, quite so. It's everything that has gone before, which relates to the question of harm. And when one looks at the way in which she deals with harm, she deals with it in a fairly brutal way to my witness. Paragraph 767 reports his conclusion, no harm, says don't be daft in paragraph 68 essentially, and then explains why she thinks that the harm is what she thinks it is in 68,
Well,
69 rather.
You know, we get into the nuance, if you like, of the lower end of the scale of less than substantial harm. Less than substantial harm being the lowest classification of harm, I think. Is it?
Yes, it's substantial, less than substantial, and nil, historically,
Yeah,
one
well,
would say.
at the lowest end, lowest superlative end of that category of less than substantial harm, it is nil harm, no harm. That's
Yes.
where it comes to an end. So, Mr. Mealy, was it?
Dr. Mealy, yes.
Dr. Mealy, contending for nil means at the lowest end of the category of less than substantial harm, which is nothing.
Yes.
And she disagreed. That's a matter of judgment. There's no question about that. She reached the judgment she did. The question is whether it had an illogical and irrelevant ingredient in it. That is the question in the case, I think.
My Lord, it is.
Not being a planner, when I read paragraph 70, I thought it only meant this. If there was something better than what's in front of me, I'd have to refuse this because it should have gone for the one that's better. But there's nothing more you can do with this. It's the only bid they've got. And so you can't refuse it on the grounds that there might be something better which could replace it. And in a sense, 70 doesn't belong there. It's a freestanding point that could go anywhere. And then she goes on, right, can't be any better. It's going to do harm. How much harm? Is that what it's trying to say, or is that not what 70 says?
My Lord, it isn't, because I think
Okay.
it is common ground between the parties that at 70 she was addressing two things. She was addressing paragraph 195 of MPPF, which she had to anyway, which asks oneself whether or not there's been minimisation of harm.
Yeah, and she's saying yes, because there's no more minimisation you could do.
Quite
And
so.
that's a separate issue.
But starting from the premise that there is development.
Yeah.
The Rule 6 party was saying the minimisation is don't develop it.
Oh.
A point raised by Mr Hardy. But that's not a point that was raised by the City Council. So dealing with that, and also dealing with the proposition that was being raised by the City Council, which was send this developer away with a flea in their ear because they're not contending that this is the only development that can come forward on the site.
But might she also? I mean, again, I'm even less of a planner than my Lord Justice Lewis. He said that. I mean, when I read this, I thought she's dealing with a separate type of harm in paragraph 70. So she's saying that she's identified issues with the design elements, and then she says straight away, but it's not these which would cause heritage harm.
Yes.
Yes.
Agree with the planning brief that any development and then she says couldn't be a different design response that could further minimise the harm. So this is part of the assessment of harm, but essentially she's saying in paragraph 70, this particular aspect, the design element of the development, is not what causes the
cause of the
heritage
harm.
What I'm focusing on is harm to the setting coming from, not being able to see the church as well as you could before. In short.
My lady's right. That seems to be a reference back to paragraph 60 of the decision, where she recognises in the conclusions of the character and appearance section that the site is challenging, and then says that there are aspects of the architectural design which would fall, she says, slightly short.
Yeah,
Bottom
so
page
she's not,
109.
she's not over the moon about the design.
No.
She recognises that it could be a lot worse, basically, as I read it.
Yes, that's not quite how I would have submitted it before Madam Inspector Searson, but my lady, yes, essentially that is what she's saying.
Yeah.
But she then goes on to address, in a slightly contrived way, paragraph 195, because she then goes on to say, having said that any development, she agrees with the planning brief, any development of this site with its constraints would affect the setting of the church, which she emphasises in 70. She then says, in this regard, I consider there could not be vastly different design responses which could further minimise the harm caused to the Grade 1 listed building. So she sort of comes to a bit more of a nuanced response that you could have developments, but you're not going to want to have ones that are vastly different, which would further minimise harm.
But it does look then that as if paragraph 70 is looking at, does this design cause harm? It's not the design that causes harm, it's the fact of filling the gap is going to overshadow the church. And there's nothing about this specific one which could be improved to make it less awful. Sorry, relate that. But that's it. So that's what she's dealing with there. She's dealing with those particular things. It's nothing to do with the physical thing, and it's nothing you could do better. But it isn't going to the separate question of if you block the view and affect the setting, what's the level of harm as a result of blocking the view and affecting the setting? That's a separate question.
My lord, yes, but she draws a conclusion relevant to that,
Yeah.
which is the sentence where she's got the emphasizer within it, where she says, I agree with the planning brief that any development at plot 12 would affect the setting of St Anne's
Yes.
Church.
Yes.
So,
Yes.
so, so the fact of interposing development in that location would have an effect.
Exactly,
she
but
says.
she's
and
not.
on this analysis,
Yeah.
sorry, I was going to say simply on this analysis, I was slightly inaccurate, I think, in characterising 70 as if it's solely to do with comparative harm. It's not solely to do with comparative harm. The first part of it is, as my lady points out, to do with design harm, if you
Yes.
But so is the last sentence. I consider there could not be a vastly different design response. Which
Yes,
could
but that's a comparative. That's a comparative point. It might be said. The question is whether that last part of 70, as it were, pollutes the logic of the harm conclusion in paragraph 71 in an unlawful way. I've used the word pollutes, that it introduces an irrelevant consideration to the question of harm. I think that's where we're finding it condenses to.
And my lord, I agree. And going back to the qualification I made a few moments ago, when one reads 70 in the overall points, you read into that everything that goes before. One reads the particular 5 words that we're focused upon carefully. The 5 words are not talking about the nature of the design response of the development. It's talking about the constraints of the plot. It's dealing with that which is physically there.
Yeah.
What are the constraints? Geography, topography, essentially. Geography because of its relationship, topography because it involves development which will necessarily go between the river and the church.
So the overall does have some purpose to play. It brings in part of 70.
Yes.
The fact that whatever you do, if you've got a gap which shows a lovely church and you put something in the gap, it's going to affect the view of the church. So there's going to be harm. Whatever you put there, the filling of the gap is going to cause harm. So that is relevant to 71. But it is a comparative. Could there be anything better? No, there couldn't be anything better. That's what's not brought in, is it?
That's exactly my point, my lord.
Right.
That's encapsulates it perfectly, if I may say so.
Right, well, we've asked you a great many questions to clarify our own understanding. Let's just pause and allow you to add anything you wished to add, because it must be your submissions to us, not our questions to you, that determine what we have to consider.
I think inevitably the submissions that I had made ran the response that I've made. Can I just add a couple of structural points, if I may?
Yes, and then I do have one more question for you before you sit.
By all means, my lord, and that's the nature of the grounds. the way in which ground 2 was put in the court below was in ground 2 Roman numeral 1, ground 2 Roman numeral 2. Ground 2 Roman numeral 2 related to giving a good reason for disagreeing with historic England's response, and the way in which Mr Justice Holgate dealt with that was essentially to say, no, she's done enough, but my conclusions on 2.1 affects 2.2. So I don't propose, unless the court wishes me to address the points in relation to 2.2. It's either I'm right on 2.1 or I'm wrong on 2.2, if that's acceptable. Yeah. My learned friend, in her Skeleton arguments, raised a secondary point, which is even if I'm right on 2.1, the Madam Inspector's reasoning in relation to arriving at the lower end of the less than substantial harm is legally inadequate. Well, I say, firstly, that's not right for all the reasons I've set out before. You can read it benevolently, and with a benevolent eye, one can understand where it goes, notwithstanding in the last hour or so of the court's time. But more importantly, what's the meaning that one gets from that paragraph? The meaning one gets is self-evident. It's less than substantial. It's at the lower end of less than substantial, and then that slots into paragraph 140, and that less than substantial harm is outweighed by the benefits which arise in this case, and that's what needs to be slotted in my respectful submission.
Isn't her assessment of the level of harm, where it is in the particular bracket, based on the analysis in the foregoing paragraph? So she set out her reasoning about the level, about what harm there is and isn't for the setting, and whether or not there's harm from the design elements. And then her conclusion at the end of 71 is what she says towards the lower end. But surely that's based on the preceding reasoning.
My lady, yes.
A judgment.
Exactly, my lady, and that's self-evident when one looks at the preceding paragraphs, which are the important, relevant elements which feed into the question of harm, rather than issues of context which go to weight.
All right.
So overall, this is not a straightforward case that was before Madam Inspector Searson for a whole host of reasons, and one could start to rewrite paragraph 71 as if one is passing the examination paper to make it crystal clear what's happening. But I say one doesn't need to, given the constraints of the court, that one needs to read this with a benevolent eye. Yeah. My lords, my lady, unless I can assist the court further.
Well, there is just one more question, which I'll ask now because I think it arises now logically anyway, and that is this. If you look at the whole thing, we know that the content of the second part of paragraph 70, which is the comparative or putative comparative exercise,
yes,
is a mandatory policy factor. We know that, and therefore it belongs in the decision letter somewhere. If it hadn't been there, then there might have been a legal error in that one.
yes.
The question in my mind is, what difference then ultimately does it all make? Because if it's a relevant factor and to be given the weight it's given, when you add this ingredient, as it were, to the recipe, it doesn't really matter. It might be submitted, because ultimately it is what it is and carries the weight that it does. It's got to be there. It's not an irrelevant consideration, it's a material consideration. And it carries the weight it does and carries the weight that it would have done wherever it arises in the decision. So ultimately, when everything is taken into account, even if this were an infelicity or worse, what difference does it actually make?
My lord, my answer would self-evidently be it doesn't make a difference, but that's because my lord is absolutely right, and it goes back to the first submission that I made very briefly, but should have made in more depth, which is planning isn't a flow diagram. Planning is an iterative exercise. Everything goes into the mix of the planning balance. Some mixing metaphors, apologies. It goes into the planning balance. My lord is quite right. It's a heritage-related issue, and it would have to be weighed in there somewhere, and therefore has been taken into account by Madam Inspector Searson.
But you're not suggesting it's simplex and it would have been the same decision. And given that it was finely balanced, if she hadn't put it at the bottom end, assuming you're wrong and she has taken an irrelevant consideration in coming to the conclusion it should be at the bottom end, we don't know whether or not she would have put it a bit further up the...
No, this isn't a simplex case.
And then you've got the problem, she says it's finely balanced.
My lord, no, and I don't make that simplex point.
You don't.
I'm picking up upon the notion that planning is iterative. One has to look at the totality of it. One has to slot that in somewhere, and even if there is infelicity in relation to whereabouts it's being slotted in, which I don't accept, but if there has, it's been weighed into that overall cauldron of
and
issues.
Properly weighed in without being influenced
I mean,
in one part of the equation by an irrelevant consideration.
Yes.
but, and this may be what my lord was concerned about, the question that the other side might raise would be this. Can we assume that the weight would be the same if it hadn't had the influence that is complained of in paragraph 71? In other words, that it didn't bring down the less than substantial harm to the lower end of that scale, but left it where it was higher up the scale.
Yes.
If it hadn't come in when it did, in other words, it's not simply a question of timing, it's a question of the weight that goes with the timing, which I thought was the point my lord was making.
Yes.
My lord, one can see the logic of that as an argument, save and accept that on that basis it has to come in any event towards the end of that process. And because it's a heritage issue, you're giving it great weight in any event. So had there been a failure against paragraph 195, we're in the notion that there has been a failure because we haven't demonstrated that we've minimised harm, and you would give great weight to that as a factor.
Yeah. I mean, logically, it could go either way. It might carry more weight if it were disjoined from the harm assessment and came in as a separate factor. That might be. It might be that it made it work. It might be that it made the case for allowing the appeal better.
Because it's still in the cauldron,
But I mean, we don't know, and the answer ultimately is we don't know. But I was just looking at the logic of the whole thing. Anyway, you've answered the question.
My lords, my lady, unless I persist the court further.
Anything else? No, thank you.
Thank
you, Mr. Tyne. Yes, Miss Foster. You have a completely free rein with the way you put your submissions to us. We have sought, as you've seen, with questions of Mr. Tucker, to understand really what the case is ultimately all about. And our questions have been directed to that, but you of course, must make your submissions entirely as you see fit.
Thank you, my lord. I've got 4 points to make by way of response to Mr. Tucker, and just to outline what those are going to be before I go through them.
Yes, very much.
The first is just to briefly touch upon what's not in dispute between the parties, which I think I can take briefly, given the discussion that's preceded my submissions.
Yes.
Secondly, to address what a fair reading of the inspector's assessment of the effect on St Anne's Church actually is. Thirdly, given the mention of the assessment of Sailor's Bethel in my learned friend's skeleton argument, I then provided my response to that, and I just want to touch on that as well, even though it wasn't spoke about in great detail just now. And fourthly, to say that even if your lordships and ladyship are not certain on what the decision letter actually says, I say that at the very least, the reasoning is inadequate because it gives rise to substantial doubt. This clearly is not a clear point, as shown by the argument we're all having on what the meaning of these paragraphs are. And so I say that in any event, the judge was right in his fallback finding on ground 2-1.
Yes.
And just to set out, I agree that on ground 2-2, that's entirely dependent on ground 2-1, so I'm just going to focus on that.
Yes. Right.
So addressing first what's not in dispute between the parties and therefore common ground at this appeal. I've set that out at paragraph 17 of my skeleton, just for your note, but I'll just emphasise 3 points now. The first is that in terms of the law and what is and isn't a relevant consideration in this regard. We're agreed, and we've heard from the discussion just now, that it's accepted, I think, by both parties that whether the level of harm to a heritage asset that would be caused could be reduced by an alternative design or could be minimised, to use different wording, that itself is irrelevant to assessing what the level of harm actually would be to an asset. And that's for the reasons that are primarily explained by Mr. Justice Holgate at paragraphs 65 and 71 of the judgment.
Yes.
Second, we're agreed as well that the level of harm, and in particular the level of less than substantial harm that this development would cause to the church, was in dispute between the parties and was a principal important controversial issue. I say that because it's relevant to my fourth point that I'm going to make before you on the reasons fallback point.
And it was in dispute because Historic England said it was moderate, or what, just remind me why it was in dispute.
Of course. So the council's witness and also the Rule 6 party's witness said it was at the moderate level. Historic England said moderate. The appellant's witness, originally the planning witness had said lower end, and then
they said it'd be lovely, it'd be nil.
Then said nothing.
So it's moderate versus hunky-dory.
Yep. And thirdly, my learned friend, as he's just clarified, doesn't challenge the exercise of the judge's discretion. So the simplex point, which is paragraphs 105 of the judgment onwards to 110. And in my submission, that's quite right, because it's clear that if this error was made, you can't say that the level of harm that the inspector found would inevitably have been at the lower end of less than substantial. It could have been higher, and of course that would have affected the weight given to that level of less than substantial harm in both her heritage and her planning balance.
Yes, so it's common ground. We're not in the simplex term.
Yes.
All right. Yes.
Turning to what a fair and straightforward reading, without being overly forensic, of the paragraphs in St Anne's Church say. Again, we're agreed as to the correct law on how one reads decision letters, and that was correctly set out by the judge at paragraph 7 of his judgment, and repeated again at paragraph 70 when he applied that law and read the decision letter. So 7 and 70.
7 and 70 in the judgment.
Yes.
Yes.
And my submission is that the judge was right, that the inspector's conclusion in paragraph 71, that this would be harm towards the lower end of the less than substantial scale, was directly informed in part by her views on whether the harm could be minimised in paragraph 70. And just to go through the St Anne's Church paragraphs, to summarise what I say she finds in each paragraph. So that's starting at page 110 of the claim bundle, starting at paragraph 63. Is the analysis on St Anne's Church. So paragraphs 63, 64 and 65 are her assessment of both what the significance of the church is, and also whether the setting of the church, which includes plot 12, contributes to that significance. And that culminates in paragraph 65, where she says that its architectural significance and historic significance that the church has got, and plot 12 clearly falls squarely within the setting of this asset and contributes to its significance. Paragraphs 66 and 67, the inspector summarises some, but not all, of the different views before her on what the level of harm would be caused by this development. As my lordship just mentioned, she summarises what Historic England say. She also summarises what the appellant says. What she doesn't do is summarise what the council say. I'm not saying that's an error, but you can see in my closing particularly, and also in the my historic buildings witnesses evidence that it was a moderate degree of less than substantial harm is what the council is saying. 68 and 69, I say that what the inspector's doing here is giving her specific findings on the nature of the harm that the development would cause. Obviously, you've already read it, and I'm sure you go back and read it again, but essentially she says that the scale and stature of this development would cause harm, but she then mentions that a visual link, albeit reduced, would still be there. And I say, crucially, she doesn't at this stage draw any conclusion as to what the level or degree of harm would be. Her analysis doesn't end there.
So by the time that's by what stage exactly?
Following paragraph 69, she doesn't draw any conclusion at that stage.
Yeah.
As to exactly where she finds it. Well, whether she finds it and where on that scale, more importantly.
So you could say in 68 she's putting the cons on one side and in 69 the pros.
Exactly
in
right,
a crude
yes.
way. Yeah.
Yes, she is. And she then immediately goes on to paragraph 70, which we've looked at. And it's here in paragraph 70, and to give you the context, the council did make an argument that where the harm had been minimised was relevant. The council said it wasn't relevant in assessing what harm would actually be caused. It's relevant in the planning balance at the end as to whether it's better to wait for a better development to come along. And we said, you don't need to approve this development just for the sake of getting a development, essentially, is what our argument was. We also, during paragraph 195 of the MPPF, and also the guidance in Historic England's Good Practice Advice Note number 3, which the judge refers to in his judgment. And we said that this particular development was too big, to put it simply, and also that it wasn't of a high quality design. And we said that those two things were causing harm, and that those two things, they could be better with a different development, purely in terms of the amount of harm caused to the church. And it's in this context, that's why the inspector says in paragraph 70 that she agreed with the council, partly agreed with the council, that there are specific design concerns, but she disagreed with the council and says it's not these design issues that cause heritage harm. And she then said that in this regard, there couldn't be a vastly different design response which could further minimise the harm caused to the Grade 1 listed church. So she disagrees with the council on that point. Then immediately following what she says in paragraph 70, only then does she draw her conclusions on the level of harm, and in particular where on the less than substantial harm scale this falls. And just to take you through what I say the important bits are about this paragraph, are that firstly the use of the word overall at the start clearly takes all the analysis in the preceding paragraphs into account, I don't say she only takes into account paragraph 70, but she clearly does take into paragraph 70 as part of her reasons for drawing her conclusion. Next, the final sentence. She gives essentially two reasons, I say, on a clear, just straightforward reading of what she says. She gives two reasons for finding the harm to be at the lower end of the scale. That's essentially one, the key constraints of the plot, and two, I say, the nature of the harm identified. And I say that this reference to two considerations tallies exactly with the analysis in the preceding paragraphs.
Yes.
So I say nature of the harm identified tallies exactly with paragraphs 68 and 69. She talks about, as your ladyship mentioned, the pros and the cons of this development.
Sorry, let me just get this absolutely clear. The nature of the harm is in 68 and 69.
Yes.
Not in 70.
No. But importantly, she doesn't say it's the nature of the harm alone as to why she's found it to be at the lower end of less than substantial. She also said it's because of the key constraints of the plot. And I say that what key constraints of the plot means is a reference back to her judgments reached in paragraph 70. The constraints of the plot are such that, in her view, you couldn't get another development which would cause less harm.
Well, all right, let's just pause on this for a second. Whatever constraints are, they may be a reason for two things. They may be a reason for the harm of this development being what it is. They may also be, analogously, if you like, a reason for no other development being any better. They can be both, can't they? But when she's assessing the harm of this development, of course, she's only concerned with the former, not the latter.
Well, she should only be concerned with the former, of
What
course.
I'm really driving at, just to see whether you agree or not, is this, that the key constraints of the site are not, as it were, logically referable only to alternative designs. They're actually relevant and pertinent to the question of harm by this development. It's the same constraints that make it impossible to do any better, she says, or she might be saying. But what the other side says is, well, obviously in context here, when she's actually assessing harm, she's considering the constraints as they affect this scheme and the harm that it does, not anything else, is what the other side says.
And I say, reading paragraph 71 in context, including with the paragraph that immediately precedes it, that when she's talking about key constraints of the plot in this sense, she quite clearly is talking about the constraints that mean that no other better development could come forward, or a development that would minimise the harm.
But she doesn't say that.
No, that's what I say a fair and clear reading of it is.
But why?
Because
Why?
the constraint, well, firstly the obvious point that it's the paragraph before, immediately before she draws her conclusion.
Suppose the paragraph had come right at the beginning.
Well, for example, and this is a point made by Mr. Justice Holgate actually in his judgment.
Yeah. Well, it's perfectly fair to say he does make this point. You're absolutely right. We want to find where he says
Yes.
what he does about it. It's the same breath, paragraph 70, I think, of the judgment, isn't it? Is that right?
Yes, paragraph 70.
No, he very definitely makes this point.
Yes,
It's the last line of 70, last sentence, rather.
Yes.
he does. And he also, so it's the point about they're in the same breath, in terms of structure, it's the paragraph before. And what Mr. Justice Holgate says is, that's this I'm just reading, sorry, from the middle of the paragraph, the third sentence. That sentence relies expressly upon the nature of the harm previously identified, for example, paragraph 69, and in the same breath relies expressly on the key constraints of the site. Those constraints were referred to in several parts of the decision letter, specifically in the context of considering alternative design solutions. I accept the submissions.
But they were also referred to in the context of considering the intrinsic or inherent harm of this proposal. And that's what it might be said. I don't know. It might be said the judge leaves out then. The test of your submission would be, why must one read the reference to key constraints of the plot as meaning only, or actually at all, the considerations that go to an alternative design? Why can't it be the considerations that go to this development and its harm? Why can't one read it in that natural way?
Well, firstly, even if it's referring to both, then...
Well, fine, but I mean, she approaches the whole thing in good faith, clearly, and with her expertise, and she's making a planning judgment. We all acknowledge that. Why should one take it that she's done the illogical thing of bringing in something that she doesn't refer to here, which is the key constraints of the plot as they affect alternative designs, rather than the key constraints of the plot as they affect this scheme, because that's assuredly what she's dealing with here, in this paragraph. I
don't think there's any further points I can make beyond what I've already said.
I mean, that's the test.
Quite. The only other point I would make is that you see, she replicates the same erroneous approach when she deals with the Sailor's Bethel.
Yeah.
Obviously, that follows her analysis in relation to the church, and it's the church that's the central issue in relation to both parties' arguments of the inquiry. But she then goes on to the Bethel.
Well, let's by all means look at the Bethel and what she says about that, because
just before we do that, I'm still obsessed, I shouldn't be, by the word plot, and I thought it helped you rather than Mr. Tucker. But I'm now wondering if plot does actually mean that gap, the hole, and the church is hemmed in, you can't do anything about that, Newcastle's spread around it, there's only the gap left where there's a plot, there's an area, and frankly, whatever you do, if there's any development, you're going to be filling in the last hole. And that's what she's saying. Given what you've got, a hole, any development when you fill it in is going to cause harm, and the harm is what she said in 68 and 69.
Yes, although, I mean, in favour of my argument is that she talks about the plot itself at paragraph 17.
Well, I thought plot linked into that, and I was wondering why she wasn't saying plot 12, and then I remembered I mustn't be too picky. But I do wonder whether she means that the plot, the area of land, the hole that's left in the vista, if you follow me. That's what she means by plot, not application site or plot 12, but just the gap, and there are key constraints on that gap. Not much you can do with it. It's a gap. You see the church through the gaps. If you put something in the gap, you wouldn't see the church.
Indeed, but that's a conclusion that she makes when talking about whether harm could be minimised.
Yeah, I mean, it does seem, I have to confess, it does seem at the moment to me that one has to focus on what she means by given the key constraints of whatever it is. But what she's doing there, it is contended against you, and she doesn't say anything different. What she's doing there is considering the harm by this scheme, by virtue of the key constraints of the plot. Whatever that means, whether it's my Lord's interpretation or some other. Why is it that one can only read it in the way that's illogical rather than in the way that is logical?
Well, I think if one is going to read it in a logical way, I'd say that my interpretation and that of the court below is the only logical way you can read this. Looking at the meeting before...
entirely entitled, of course, to draw upon the characteristically thorough analysis of Mr. Justice Holgate. But in paragraph 70 of his judgment, which we were looking at just now, reading that, of course, in its context and as a whole, which one must do to a judgment as well as to a decision letter. Why is it that it's only the alternative design solutions, or at all the alternative design solutions that she's dealing with when she's talking about the level of harm to St Anne's Church, i.e. by this development? When she says the level of harm to St Anne's Church is less than substantial, that can only be a reference to this development, because nothing else is. This is, it's the development here that is, and that is what she's considering. But it may be said.
Quite clearly, she's drawing a conclusion on what the harm that this development would cause is.
Yeah.
The problem is that that's directly informed in part by her judgment in paragraph 70 that the harm has been minimised here.
And the question in the case is it?
It is, exactly.
So it's a question. I mean, ultimately, both sides come up against that end point, which is how should we read it? And ultimately, you've both made your very clear submissions on that.
Indeed, and of course, there is also my fallback submission, which I'll come to at the end.
No, sure, we're coming to that.
Clear.
No, I'm not in any way seeking to foreshorten that. But we were going off to Sailor's Bethel.
Yes.
Which we haven't actually looked at, 76 and 77.
Yes. And of course, the analysis starts at 72.
Yeah.
What I say, obviously, one reads all of the paragraphs as a whole, but the key paragraphs are probably 75, 76 and 77. Before that, she's again talking about the significance of the asset itself.
So we should read really 75, 76 and 77 together.
Yes.
I was trying to work out when I did that what she meant by this specific vantage point, and I thought she must have meant from City Road.
No.
Is that not right?
No, she means, and you can get the specific vantage point
oh, I see.
in the supplementary bundle.
Okay.
So it was referred to as viewpoint 15 at the inquiry.
Okay, viewpoint 15.
And that's at page 88 of the supplementary bundle.
'78.
88.
88, sorry. Yeah, okay.
And you can see there the top photograph is what it is currently. And you can see the Bethel because you can see the spire. Do you see at the end of the bridge essentially?
Yeah, sorry, it's
It's not a particularly well used image.
No, it doesn't. It doesn't come out very well.
But you can identify it because in the bottom photograph with the development, essentially the proposed development is in white and it goes either side to the right and the left of the Bethel.
Yeah. Yes, I see, yeah. And that's the viewpoint she's talking about.
That's the viewpoint she's talking about. The council said that causes harm, the appellant said that doesn't.
Okay, yes, I've got it now, thank you. That's very clear. I shall need to get my magnifying glass out to read those captions. You can see the Tyne Bridge in the distance.
Yes.
Right, so then so that's 75. And then the point that you say helps you is which one?
It's paragraph 76.
Yeah.
So again, I say this is still part of her analysis, in which she then concludes in 77 there's no harm, no less substantial harm even. But in 76, she says that in assessing the harm, she says that she's mindful that any development of this site would be seen from this specific vantage point, viewpoint 15. The development would, however, preserve the views of the flesh, I think that's pronounced,
Yes.
in the skyline, and the distinctive shape of the roofline would still be readily distinguishable.
Flesh means arrow, doesn't it?
I think so.
And the Sailor's Bethel does it have an arrow on its?
It does.
Well,
the
it sort of has a
four-lead covered
very
flesh on top of the
thin,
belfry.
a very
yeah.
thin
On
spire.
the belfry,
Yes,
yeah.
I think there's a reference to the very thin
So
spire.
so you know that's where the Bethel is. You see the flesh and you know it's there.
I'm not
So-
quite sure, sorry to be slow, I don't quite see how paragraph 76 has any help at all for working out what 70 and 71 mean. I mean, she's moved on then from St Anne's, she's into non-conformity at this stage.
I think the answer, if I may say what I've understood. You are saying that what she does at 76 is actually very much what she's done at 71, which is to mix together the two things which aren't to be mixed together, which are the harm caused by the development itself and harm that might be caused by any development of this site.
Oh, I see.
And taking that into account is, she's demonstrated, you might say, I don't know, that it's a starker example of what you say is wrong with 71. But still, one just has to look at the language used. She's not actually, is she there even, saying that the harm is only what it is because it can't be any better?
No, I say the error is crystal clear in paragraph 70 and 71.
Yeah.
The reason I mention the Bethel is because it was said by my learned friend, in writing at least, that, hang on a second, the council hasn't complained about what happened with the Bethel. If the inspector was right on the Bethel, they're right on the church. And I've said, and I've said actually,
So,
she's also wrong on the Bethel.
But it
if
doesn't
that
matter
helps.
because as long as she's wrong on one thing, you don't really mind,
Yeah,
really.
I mean,
Yes.
it may be that your argument is none the weaker or the stronger for reference to those paragraphs.
Quite. It's only if one were to look at it, I say, if anything, it supports.
It comes down narrower and narrower, doesn't it, as we think about it and listen to these submissions, to this whole question of what she meant, or arguably must have meant, by given the key constraints of the plot, and that's where the diametric difference is between the two sides. Yeah. You
Indeed.
say, you have the supplementary point, that the very existence of that debate, you say, is a ground in itself.
Indeed. And I think I've made all the submissions I can on everything but the reasons.
Well, just take a pause for a moment and be sure that that's right, because we have been asking you questions. And we do want to make absolutely sure that we've got everything you want to say on the main point.
I have, thank you.
Sure.
Yes.
Okay.
And turning to the reasons ground, which is dealt with by the court below at paragraph 72 of the judgment. And that's to say that even if your lordships and ladyships aren't certain on the reading of the decision letter, it's quite clear that the point is not clear. Sorry, that's a bit confusing way to say it.
That's a neat way of putting the submission. It's clear that the point isn't clear.
Yes, and that in relation to the standard of reasons that's set out in the Save case and also South Bucks, this was a point of dispute at the inquiry, what the level of less than substantial harm would be. That's agreed, and it's also agreed it was a principal, important, controversial issue, as referred to in paragraph 36 of South Bucks. And I say that looking at the decision for all the reasons we've just gone through, at the very least, on the face of it, this issue does give rise to substantial doubt as to whether or not the inspector's conclusion in 71 took into account her views in 70. And I say in reality, even on the appellant's highest case, they can't overcome this error. As Mr. Tucker said in his submissions just now, and I wrote this down, he said, I agree, it's not entirely clear. I did note that down. And I agree, it's not entirely clear. There is, at the very least...
No, but it means but it's clear enough. What he's sorry. I imagine what he's going to say in a minute.
Well, you say it's not entirely clear, and it's not clear enough. And that's the difference between
It is, and to use the wording of the case law, it gives rise to substantial doubt as to whether the inspector...
Yeah, which is the test.
...took into account.
And you adopt the judge's reasoning on that?
I do.
Just to humour the judge is even worse than counsel. He's got the key constraints of the site twice in paragraph 70, and then he switches to key constraints of the plot in paragraph 72. It's strange that the word has changed. I don't think it matters.
It may simply be that he regarded them as synonymous.
As interchangeable, actually, and it means not the application site, but it means that area stuck between the two current buildings. It's the gap, as they call it.
I mean, the site is, strictly speaking, the site is the red line.
Yes, the application site.
And the plot might be a wee bit bigger.
Anyway, I just noticed that I was
But
criticising
they are
you, but
similar
Mr. Horrigan
looking
does
at
it
the
even
map.
worse.
I mean, are they?
Well, that's very clear. So, just taking stock. What next?
I think those are all the main points I wanted to make. In
Obviously, we
response.
read your skeleton argument and you adopt the written submissions as your case, as well as the oral submissions you've made to us. Well, that's it. Yes, thank you very much. Thank you very much, Ms. Foster. Yes, any reply, Mr.
I've got 3 points, my lords, my lady, if I may. And I've scribbled out not clear enough. So that's not my 4th point. The first point is really in answer to the question which has been left somewhat pregnant, which is the use of the term plot with lowercase rather than plot capital letter. Having done a word search in relation to that, I say having done a word search, I mean Mr. Humphreys has done a word search, for which I'm enormously grateful. Lowercase plot appears once in the decision, and that's to be found at 71. Plots, plural, lowercase, appears at 50. And at 50, at page 108, it talks about this pattern is somewhat subtle. This is talking about the nature of the quayside, with each of the developed plots taking on its own architectural character. So she appears to be talking about something in relation to the quayside when she's talking about plots, but the only use of plot is there, and she uses the term plot with a capital by reference to plot 12 4 times in this section. That's at paragraph 64. 4 times: 64, 65, 66, and 70.
It's probably a conveyancing plot. It's an area of land, I think. Yeah, the gap.
Perhaps. I mean, I have to concede it has the definite article before it, but nonetheless, she does appear to use plot 12 specifically in 4 places in the preceding paragraphs. Yep. And in relation to that, the first point, just to come back on, is I agree absolutely with what my learned friend said about the structure of the first paragraphs of these couple of pages, because she discusses significance 65 to 60, 63 to 65. I agree. And included within that discussion of significance is the sentence that I read out at the start of my submission, namely, St Anne's overlooks the quayside across plots 12, and although accidental and unplanned, clear views of the church are enjoyed from this area and have been for a considerable number of years. So that's part of the significance element that she's considering.
Well, she also says at the end of 65, as a cleared site, plot
Yes.
12. So that equates site and plot conceivably in the sense of plot 12 being a plot.
But perhaps, my lord.
Perhaps, yeah.
But my point is that looking at the history of the matter, that's part and parcel of her discussion of significance. And obviously significance is part and parcel of what one looks at in terms of what is being impacted by the development.
Yes.
Second point is I agree with my learned friend that paragraph 71 can only logically be read back to incorporate the discussion of impact. So paragraph 68 and 69, the difference between us essentially is whether it also incorporates the impermissible parts of paragraph 70, on which I won't repeat my submissions, because submissions don't get better by repetition. But my final point, if I may, is when one reads this section and reads the notion of if the plot does mean something wider than plot 12, what is it about the topography of this area which might be key constraints? Well, just taking them in turn, and my lords, my lady will read the totality of this, but to cherry pick a few, the end of paragraph 63, within the significance section, it is set in a graveyard which slopes down towards the city road and is bounded by stone walls and railings. It's on a sloping site. 64 due to its, St Anne's Church, position on top of the plateau above City Road, it has a visual presence in the wider area. The tower is visible across a long distance as past the backdrop of the Newcastle skyline before talking about the gap. In other words, its presence on the top of the plateau, along with the gap, provides that degree of wider presence.
You're going to hate me now, Mr. Tucker. That would make sense if paragraph 71 said, given the key constraints on the plot. But the problem that I started off with, I had thought that 71 referred back to 64. But 64 is dealing with the church, which is the thing that is looking down on the plot, not the key constraints of the plot, if you follow me. Sorry,
no,
I knew you'd not like that.
No, my lord's absolutely right to pick up on that, because I say it's not just the church, and that's not the submission I'm making. It is the plot, because it is the gap, i.e. the relationship of the church to the river is part of its significance. That is facilitated by the fact that one has church up here, site sloping down and river at the bottom, and nothing in between. That's essentially my point.
A constraint is something which operates to make more difficult, let's say, or challenging, to use a modern word, that which one is about to do. And there's a reciprocity between describing what it is that creates the constraint and then considering what the constraint of that is upon that which you wish to do.
Quite so, and the dynamic that we're considering is the effect on significance of the historic asset, and the historic asset has significance which is drawn from the gap by virtue of the relationship to the river and by virtue of the topography and the geography, etc. Read in that way, there is
reciprocity.
Yes.
Useful.
And I draw attention as well in 68 to the open aspect of the quayside is only a consequence of site clearance, a view that's been open and enjoyed for a significant period, which the development will visually interrupt. That's the impact that she's identifying. Logically, that arises because of the openness of the plot, by which I do mean plot with a lowercase and also an uppercase. My lords, those were my only submissions in response, unless I can insist the court further.
Thank you very much. Yes,
I'm very sorry, I know I'm not permitted to say anything further. It's just a point of clarity.
Yes, of course.
Is that we were talking about whether a word search had been done as to whether the word constraints came up in the decision. And just a point of correction, it does come up in paragraph 145. The word
Thank you very much. That's really helpful. So that's constraint or constraints. You've done a search on
constraints with an S is in paragraph 145.
Yeah, so that would, your word, all I'm asking is that your word search would have included both constraint and constraints.
Yes.
Yeah. Okay, and that's in paragraph 145.
Which ironically qualifies the word site.
Yes,
so we come full circle.
Right. Thank you. We'll read the decision letter again and again, fully, we promise.
And I shall of course join my learned friends crossword club.
Right. Well, thank you both very much for extremely able submissions, both of you. Thank you. I'm very grateful to you. You've given us plenty to think about. We shall go and reflect on what you've said to us, and of course what you've written in your skeleton arguments too. We're grateful to all who have been involved in the production of materials for the court. Thank you. We are not going to give judgment now. We're going to reserve our judgment. A draft of the judgment or judgments will be sent to you in due course in the normal way. The purpose of doing so is not to invite you to take issue with the substantive content of the judgment or judgments, but simply to offer suggested typographical or other minor factual corrections. At the same time, a draft order should be prepared and submitted to the court according to the timescale indicated, and any submissions on any consequential matters submitted at the same time, all of which, of course, is familiar because it is the normal way of proceeding. We do emphasise, as we must, the impure arrangements which will obtain at that stage. Those are important requirements. They're spelt out, and they must be rigorously adhered to.
My Lord, might I ask one question of clarity in relation to a point that I asked at the very outset,
Yes.
which is self-evidently the Secretary of State isn't here, but
Yes.
has made observations with respect to the order. It may be sensible via the learned associate to ensure the Secretary of State is therefore covered by any circulation of the draft judgment
Yes.
and the discussion of order. I just say that because it's possible that they might
Yes.
otherwise be missed.
Yes, no, that's a helpful suggestion and one that we shall heed. Thank you very much.
Obliged, my Lord.
Thank you.
Authorised.